deal with those activities that could reasonably be contemplated to occur in an SNA or where there is significant bush, but for whatever reason that they haven't been provided for. And because network utilities are a wonderful example, as is infrastructure, and infrastructure operators run up and down the country getting themselves sort of special exemptions from rules because of the activity they do, and they've got policy statements that provide for it. And so we end up with a rule that is permitted, non-complying, but they end up somewhere in the middle, so that it's a sort of a signal that they ought to get a fair, I guess, an easier ride through because they're important. The other day we had an example of a landowner who, for probably an accident of history, I would suggest, has ended up where his only legal access to his property is not his actual physical access, but if he lost that physical access, it would only be accessible through an SNA area. And the way the rules are constructed, there seems to be quite a hard road, no pun intended, for him to secure access to his land. I mean, do you see that there's capacity to highlight those sorts of situations and put them somewhere in between permitted and non-complying?
I definitely do. I would just be concerned with how broad those, like what they actually provide for, and scales regarding how much clearance was involved. And then also, sorry, but when it comes to well, network utilities infrastructure, it almost sounded like there was a problem in and of itself, not quite covering what the activities were, but there was something around where there's a functional and operational need for the activity to locate in the SNA. I think operational need would be too broad, and even like seeing how the regional council applies the term functional need. In my reading of it, it's very tight, but it seems to have been applied rather loosely in practice from what we've seen so far. I would have concerns, but I do see that there is the need for that middle ground for.
Because at the moment, the middle ground is actually created by the policy to some extent, isn't it? The policy is quite explicit in what's contemplated, rather than it having a different activity status. I mean, do you have any advice on what, from a whole package of policies and rules and objective, what's the better approach to really set the bar high with a status, but then use the policies to differentiate what ones can get consent and what ones can't, or to create a separate class of activity that doesn't have that non-complying stigma attached to it?
Yeah, I would just be reluctant to go for the middle ground, because without clarity as to what the activities would actually entail.
I guess just reflecting on that, and it's probably, I'm just sort of thinking out loud, that the policy can be a little bit more flexible of an expression, because that's the thing that you would apply to the circumstances of any particular case, whereas a rule's got to be really quite finely crafted to work, doesn't it?
Yes.
Okay. I did have another matter. I was interested in your paragraph 47, where you said council have granted non-complying subdivision consent applications non-notified under rule Eco R6, where subdivision of land has occurred but no protection is offered for the SNA. Where have you seen that example? Is that in this district? Obviously it has to be.
Yeah, well, it's in my previous role prior to working at Te Teitanga, I worked at a local consultancy firm, and I can remember a couple of applications where we did not propose to protect an SNA via a conservation covenant, but yeah.
So was there, oh look, I mean, I'm really interested in this. What were the circumstances then that the applicant effectively got resource consent but didn't make good on the protection? unless of course it's confidential based on your previous practice, but and you can tell me that if it is, and I'll drop it.
I'm not sure so much is confidential, and that was kind of just, yeah, I probably actually should have obtained those examples to provide to the panel, perhaps.
Mm.
I
Yeah. Oh no, look, that's fine. I mean, obviously, there's no proposal here to create prohibited activities, as far as I can tell. So it is always open to an applicant to ignore the rules and do what they want, and go through as a non-complying activity. But I suspect what we potentially have with the proposed plan, which we didn't have with the operative plan, is you've got a much more comprehensive policy regime to measure it against and potentially provide reasons to refuse it. Would you agree with that?
Yes.
Yeah. Okay. All right. Thank you, Mr. Chair. Thank you, Ms. Bellamy. That was very helpful. Thank you.
Thank you, Commissioner McMahon.
Thank you, Stephen. Good afternoon, Ms. Bellamy. Can you hear me okay, Ms. Bellamy?
It's just been quiet. Kia ora.
Does that move forward towards you, or is it stuck?
Is that better?
That's better.
Yeah.
Okay.
Sorry about that.
Ms. Bellamy, I'm just going to start at the back in your Appendix 1, marked up version, and it looks pretty sparse, and I guess I just want to understand the reasons for that. And I'm assuming the reason is that most of the issues that you've summarised in your evidence in chief are asking for the retention of provisions as notified. Is that the reason?
Yes.
Right. So just picking up on Commissioner Littlejohn's earlier question about policies P3 and P4 as notified, and I have just had a quick look at those, and there was, in relation to, say, network utilities infrastructure, a policy that provided for the maintenance and repair of existing infrastructure and network utilities. So you seem to be happy to accept that policy.
Yes, in terms of maintenance and repair and operation.
Yes, okay. Seems to be a slightly different situation there than Maria was presenting to us before the afternoon tea adjournment.
Yes, for the outstanding natural landscapes and features.
Well, this rule relates to this policy relates to Indigenous vegetation disturbance within the SNAs and the coastal environment.
Yes, but I think Maria's comment was in relation to the outstanding natural landscapes and features provision.
That wasn't how I asked the question, but
Okay.
I was focusing solely on SNAs. She asked for the words network utilities to be removed, I thought, from the SNA rules.
I think it was from the NFL rules.
Hang on a minute. Okay, yes, I stand corrected. You were right on that. Oh, that places her answer in a different context. Okay, I'll reflect on that. Thank you for that clarification. guess the only other issue, and it's one that again Commissioner Littlejohn identified, and that's this middle ground. In a sense, vegetation clearance rule that the Department of Conservation is suggesting, and which I think most iwi groups are supporting, which is I think it's a restricted discretionary rule with obviously a spatial area of clearance allowed or being triggered to maintain the discretionary activity status. Could be considered to be a sort of a middle ground for the protection of Indigenous vegetation. And I guess I don't know whether Commissioner Littlejohn was thinking of this, but the middle ground that was exploring with you is for the provision of those activities that might be considered to be appropriate or not represent inappropriate development, infrastructure and utilities and the likes, tracks. So I just want to explore that very briefly with you, because I think it would be a very good topic for planning conferencing to tackle, and for the panel to hear the respective views of people involved in that planning conferencing. But for the current purposes, so Ms. Bellamy, what I'm hearing from you is that such a rule would have to be crafted very carefully.
Correct.
Right. And I guess the bottom line would be the ability for the council to approve or decline the application based on its merits.
Yes.
And the two activity statuses that would benefit from or enable that other than non-complying would be discretionary activity, unrestricted, and restricted discretionary activity. You'd agree?
Yes.
And are the effects of the activity of resource able to be identified with some certainty? I mean, what are the areas of discretion that the council might want to exercise its mind to when considering the effective appearance of vegetation where it might involve infrastructure or a utility?
Yeah, so scale would be one.
Yes. Okay. Right. A cross-reference back to P01, dealing with the matters that create the importance for the resource in the first place?
Yes, as well.
And do you think those matters could be identified as matters of discretion, as opposed to having the role open-ended as fully discretionary? I mean, I guess what I'm trying to understand is, could the effects be ring-fenced in a way that would enable restricted discretionary activity to be used as opposed to discretionary activity?
So would that be including P1 as a matter of discretion under the rule?
I don't want to get too much into that, but possibly, yes.
Yeah, I think that, yes.
A case, and I don't know whether it came up in hearing stream 1. I think Commissioner Littlejohn might have mentioned it was a case by Judge Kirkpatrick, which I think it was Judge Kirkpatrick that talked about where it might have been a case actually that was introduced by Mr. Matheson to the panel, when it talked about where you can control effects adequately, you should look to use the lowest activity status that would deliver that outcome. Kit will correct me if I've got the reference wrong, I'm sure, but are you familiar with that sort of edict, if you like?
No.
Kit, do you want to just come in here and on that?
I'm not entirely clear what you're talking about.
Okay,
David.
Okay.
Sorry, there was a decision by Judge Kirkpatrick, that was the Eden and Thames Coromandel decision, yes, which we referred to the council staff, which talked about if you're going to make things restricted discretionary, you should make them as clear as possible.
No, it wasn't that case. It wasn't that case.
Yeah.
There was another case, and maybe I'm getting my forums mixed up, Kit, but I'm aware of a case, and I thought it was Judge Kirkpatrick, that's where he said that where the effects can be dealt with through a lower status consent activity, there's a compulsion on a planning body to use that in terms of Section 32, because that's more efficient and effective, so long as the outcomes that could be achieved through that activity status are achievable and potentially the right ones. So probably very little I can ask you, Ms. Bellamy, about that, because A, I haven't explained it very well, and B, you're not aware of it anyway. But maybe I'll dig that out, and if there is some planning conferencing occurring, maybe some reference to that might be appropriate.
Okay, thank you.
Aside from that, I guess I'm very keen to see what those attending any planning conferencing might come up with. I think we could use the collective minds to assist us in that respect. A wise use of resources. That's all I'll say on that. But that's all for me, Stephen.
Thank you, Commissioner McMahon. Casey, you're the last planner standing in terms of the SNA matters. So I do want to, as a planner, I do want to explore a particular issue with you, just to get your opinion. Perhaps, Julie, could we bring up Ms. Yosen's evidence for DOC? And I particularly want to look at her Appendix 2 or B, page 34. This won't be too hard, so I just want you to work your way through, get your planner's mind to work your way through how you read the situation, Casey. And it is in tune with, your general evidence. So we're going right to the back. There's some landscape tables. It's probably the second last page in the whole thing, the whole brief of evidence. In the landscape tables, you can go right to the back, right down the bottom. Okay, this is the one here. All right, so just to orientate ourselves, these are the new vegetation clearance rules that are being proposed by DOC in terms of the district-wide rules. And this is the permitted activity rule, which talks about vegetation disturbance. Can you see that there?
I can't see it, but I can put it up on my.
Yes, it would be. Okay, let's blow it up. Can you see that now?
Go a tiny bit more. It'd be. Yep.
Okay. So it says where the Indigenous vegetation disturbance. We're talking about clearing bush. Okay, is necessary for those matters, and then just over the page there's this exemption. So number 2, so it's permitted where the clearance is not for the purposes identified above. An extent of Indigenous vegetation disturbed and or cleared per site does not exceed an area of 250 square metres. So this is their proposal in 5 years. The rates for Indigenous vegetation, that's the way you read that. So it's not to do with habitats or anything, it's just Indigenous vegetation. Right, now applying the planner's mind, and I set this up with Maria previously about the discussion we had about if you extend that to habitats of Indigenous fauna, and you think about skinks or lizards that sit on rocks or run around in the back garden in your home in Napier or Napier, New Plymouth, kiwi and pine forests. Now, I'd like you to ask your opinion about the position put by Forest and Bird in relation to their request. So what Forest and Bird are saying, that they support this relief by DOC, subject to these rules we're dealing with here, the new permitted and discretionary rules, applying or being amended to cover all the matters in Eco P1. Now we need to go and look at Eco P1.
I've got that.
You've got that
one
here. So Eco P1 deals with a whole range of criteria, doesn't it?
Yes.
And that includes the habitats of Indigenous fauna,
It does.
which could be all sorts of habitats around the district.
Yes.
And you'd agree that, think about seagulls or anything that's moving around the district, that would include them.
Yes.
And if we took the Forest and Bird position, they seem to be applying or seeking that where vegetation clearance is referred, they should be replaced with all of those matters in Eco P1, which includes the habitat of fauna. There's sort of a missing gap that this clearance should also apply to areas that are subject to habitats of Indigenous fauna. Now, as a planner, is that the way you'd read what they're seeking as well?
I'd probably need to go back and see what.
Have a look at that.
Yeah.
Yes, that might be something that the planners could look at. It's really just and we don't have a planner for Forest and Bird, but it's just my reading of their paragraph 7 in Mr. What's his name? Mr. Jennings' legal submissions that adopted Ms. Yosen's evidence, but it was subject to, and I was just really wanting to understand where the position they were asking for was to add in the habitat into the vegetation clearance rules that Ms. Yosen's requesting. Is that clear?
Sorry, sir. So, in the conferencing,
Yes.
to get the position of all the planners
Yes.
on Ms. Yosen's proposed rule.
Yes.
So what?
And it's,
So how does Mr.
well,
Jennings fit into
my
that?
reasons is that Forest and Bird are seeking for that to be extended.
Right.
And what wasn't very helpful with Mr. Jennings was he didn't actually include a markup. But I think that's come in now on our request of the rules. So I haven't seen that yet.
No.
But if what I'm expecting when I do see it, or as I think what I'm reading in the submission, is that those rules in Ms. Yosen's, those new rules, would also extend to the habitat of Indigenous fauna as well.
So Ms. Yosen is recommending that, and Mr. Jennings is asking for it to go that bit further to the habitat.
That's
and
right.
you would like the planners to come back.
Yes,
thank you.
that's
clear.
my reason. So it's been a bit of a roundabout, but it is a key question about how far this intermediate position might go, and what might be planning reasons and the Section 32AA matters that might apply if we took what I think is Forest and Bird's position to the extent that they're seeking. So thank you just for indulging me there. I just wanted to get that on the table. in the planning context. I do have a couple of other questions. This is around your mention about the higher order planning documents that relate to Mataranga Maori and how that might come into play. You mentioned section 6E, CE, 7A, 7D, and policies in the Taranaki Regional Policy Statement. You also mentioned the iwi management plans. Do you see those as higher order documents? Planning documents? Having regard to? Do you see that they sit above the district plan?
Yes, providing, rohi-based guidance regarding resource management outcomes.
But when we have to have regard or give effect to higher order documents, do you see the iwi management plans having the same status as the RPS? Or, because I think that's what you've told us.
Yeah, well, as a matter to take into account.
I think we've got to carefully look at the words. We need to have regard to. Is the iwi management plan a higher order document than the district planning document?
I would think so, yes.
Okay, thank you. And another question I had was around the strategic directions objectives where we've issued some interim guidance, and you mentioned some of those policies, those objectives which we have suggested maybe should be changed in the interim guidance. Do you have any comment on those in relation to how these chapters apply? Are you comfortable with the interim guidance version, or do you have any thoughts on that?
I think they flow down into the chapters.
Okay, so you're comfortable with those as we've suggested?
Yes.
Okay,
Yes.
thank you. I did have one last question, and it was around your paragraph 28. And this is where you talk about the 2015 State of the Environment Report, having less than 10% of original forest cover. That's based on 2008 to 2012 data, which is 10 years old. Is there any update? They must have had a State of the Environment Report post 2015. Was that the latest one?
That's the latest one I could find.
The Regional Council's done.
I'm not aware of any more recency.
Okay. No, that's good. Thank you. That's all the questions I have. Thank you very much.
Thank you.
This is Marco.
It's a big cousin now. Well, tēnā tātou, i ngā kai kohimana, tēnā koutou, i ngā kaimahi o Te Kaunihiro o Ngāmatu, tēnā koutou. I te iwi, kei konei, te huitupa, tēnā koutou. Kua tai mai ki te kōrero e pāna ki te tai au. He uriau no Ngāro Henerangi Ngāti Rangitihi me Ngāti Whetikaupeka, e mahi ana au ki te koteitanga o te atiawa, e pautai au. Ko Sera mako tōku ingoa, nō reira, tēnā koutou. So great to be back. Been a long couple of days, and just a really big mihi to the hearings administrators for helping us to pull this together. and your assistance in that as well. Very much appreciated. It's obviously these chapters are a kaupapa that are really critical to the tangata whenua submitters. So I'm really grateful for all of your support as well, those that are hopefully online as well. So just one thing I wanted to start with, I think got a fair few hearings to go, so just sort of give a rundown on my how to pronounce my surname, if that was okay. So Mako is actually shortened from Mako Wharemahihi. So if you prefer to use my full name, I'm also happy with that. I'm happy for you to call me Miss Mako. I'm also happy for you to call me Sarah. So anyway, kia ora.
Kia ora.
So really just wanted to touch on a couple of things. One was the transfer of powers kōrero which we've had. So we heard some really rich kōrero from both Jamie and Te Poihi yesterday in terms of te kāhui maunga, the system of maunga and also including ngā motu as well. So in terms of those Section 33 transfer of powers, I appreciate that they're outside of the scope of this proposed district plan, but it was really important to raise given that the maunga negotiation settlement team are working through that at the moment. So I think it's really critical from my planning perspective that that the proposed district plan has those provisions which should anticipate what will come through in the settlement, and also to reflect on, in Aotearoa that tangata whenua are through treaty settlements are leading the way regarding personhood of our tupuna, of our natural and physical resources. So just one thing that I did to check, and actually one other thing to clarify is that Maria and Casey went before me because they're actually the planning geeks. I'm on the lower order of that, so that's why I was going last. And that's why I'm also using written notes as well still. So just wanted you to turn your attention to my evidence, paragraph 10. So I've actually, in paragraph 10, I've written Te Kotaitanga has raised in its submission the intention of ngā iwi o Taranaki, ngā rauru ki tahi, Ngāti Ruanui, ngā rohine, Taranaki iwi, Te Atiawa, Ngāti Mutunga, Ngāti Tama, and Te Runanga o Ngāti Maru to shortly pursue a Section 33 transfer of powers. So I just wanted to clarify that Te Kotaitanga doesn't at all, and myself don't speak on behalf of those iwi, but through the maunga negotiations team that's how all of the other iwi, ngā iwi o Taranaki will raise that Section 33 transfer of powers. So just, I'm not sure if how you do want to do this, Commissioner Dash, if my summary of my evidence will just flow similar to my evidence, so if you want to ask questions that way, yes, or to carry on, because I'd move on to mikotahi now, if that was okay.
Yes, look, we did, I'll just seek some views from the commissioners. Are we happy for Sarah to go through her whole summary and then ask in the round, or do you want to do it by sections? Commissioner Coffin, do you have a view?
I've actually got a hui at 5, so...
Okay.
I was happy for Sarah to just go through her evidence.
Okay, come on.
Okay.
Okay, well,
Yep, I'm in the same position. Happy for you to get through it. We've read it all, so just, I'm happy for you to highlight the points, and we may have a couple of questions for you.
Sure.
We have the benefit of knowing you're not going anywhere for the next 12 months like us.
So on mikotahi, I just wanted to turn your attention to the cultural values statement that's appended to my, the cultural values statement prepared by Ngāti Te Whiti that's appended to my evidence as well. and the table on the back. And aroha mai, I've just realised that my evidence, it doesn't have page numbers on it, so I'll make sure I address that for the next set. So in the table at the back of Appendix 2, it identifies ngā kaupapa, so a number of values, as well as whakatauki, that through the process of the development of the cultural values statement, Ngāti Te Whiti have identified, and Sean and myself were able to articulate that. And we know that it's not ideal to do it in these table formats, but this was the best way for us at that time. So just wanted to draw your attention to ngā whakatauki, so in particular, with the value rangatira me te mana, so paritutu te pou tu moana, tu I te ao, tu I te pō. So paritutu, a rock standing firm in the sea day and night. The next one, the value of kaitiakitanga. Ko te whenua te kiko, ko ngā wai, te toto. Ko te maunga, te tupuna, ko tēnei te tūranga waiwai. We know these lands, and these lands know us. We are in every blade of grass and in every grain of sand. Just two that I really wanted to highlight to emphasise that importance of mikotahi, and I know that obviously today when Julie, Whaia Julie was questioned around that importance of mikotahi, that significance of mikotahi in amongst ngā motu, that she probably understated it a little bit, and I understand through my planning perspective and through the relationship I've developed with Ngāti Te Whiti, and particularly in the development of that cultural values statement, is that actually mikotahi is much more important than you probably think. Obviously, the waiata that Julie and Andres also sung to tautoko Julie this morning, the first ingoa is mikotahi. So just, I think it was, from a planning perspective, I definitely can appreciate and understand the importance of mikotahi. So there was a question as well around what I've based my assessment on. So it's obviously I've had the benefit of the evidence from Ngāti Te Whiti, but also had reviewed the evidence of Mr. Richard Bain as well, informing my planning opinion. So I did state in my evidence as well that I did agree with Richard Bain's assessment. There was also a question around that mikotahi is also identified as a site and area of significance to Māori, and also an archaeological site. And there was a discussion earlier around that, and in my opinion, the sites and areas of significance to Māori and the archaeological sites, but particularly the sites and areas of significance to Māori, is that it's very narrow. You're only required to consider that site and area in isolation, yet in my opinion, they form a much greater landscape, but there's not that ability to consider them at a landscape level, whereas under the ONFL, in my opinion, they are considered at a landscape level. And just something further to add is, and aroha mai, I haven't discussed this with Ngāti Te Whiti, the whānau from Ngāti Te Whiti, is that there's actually, if it would be useful, there is a Wakahuia documentary. It's available on YouTube, and it's just called Ngā Motu, and it's actually Rangi Kōtuku Rukuwai, so who was a kaumātua of Ngāti Te Whiti, so he was interviewed about ngā motu, and provides a Ngāti Te Whiti perspective about that. So happy to share the links for that as well, but it will provide further background to the importance of mikotahi in considering it at the landscape level. So moving on to water bodies, I guess the corridor that we've heard over the last couple of days is that, you know, freshwater has its own mauri, it has its own mana, and that it is the essence of life, and that is now reiterated in the National Policy Statement for Freshwater Management as well. So from a planning perspective, I support the retention of the water bodies chapter. I've articulated through the evidence why I think why it is a function of a territorial authority. So one thing, actually, we had a little bit of a debrief last night after yesterday's session, so just to prepare for today. So just wanted to talk to as well, and Commissioner Dace, you raised earlier with Maria, I think, around is Indigenous biodiversity only restricted to the ngahere, so only to bush areas, and in my opinion, Indigenous biodiversity isn't. Well, I'm not sure that I'm sure there's case law, but I'm not sure of that. That Indigenous biodiversity also covers wetlands. It covers rivers as well. So that from a planning perspective, I think when we consider Te Poihi's corridor and Jamie's corridor yesterday, is that all of these natural and physical resources can't be viewed in isolation. They are all very important corridors for all of our Indigenous biodiversity. And I know that there's been a line of questioning also around how Indigenous biodiversity and Te Mana o Te Wai link as well. And in my opinion, there's mahinga kai is now also a compulsory value and consideration under the NPS for freshwater management, and that flows into that flows into water bodies as well. So it's a consideration. Mahinga kai should be a consideration in that Indigenous biodiversity chapter, and aroha, I'm not entirely across that, but I was last night when we did debrief. So so that's where I can see the links between Te Mana o Te Wai and Indigenous biodiversity. So just briefly on the scheduling approach, I think my evidence is relatively clear that the scheduling approach does restrict the expectations of tangata whenua. It also narrows the application of Te Mana o Te Wai. So I have to double check that, but that the setback in relation to earthworks and buildings and also esplanade areas should apply to all rivers, all water bodies. And I'm sure there'll be a line of questioning about that. One thing that I did consider while Maria was speaking as well is around the definitions. And perhaps there's an opportunity, because of what Maria raised around setbacks should apply also to piped water bodies. I think that there's potentially, I'm sorry, just taking a step back, in the definition of a significant water body, it only refers to the definition of water bodies in section 2 of the RMA. So that would mean that if there is any water body that is piped, and I also appreciate in Schedule 9 that there are 2 instances where those piped sections of significant water bodies are excluded, that potentially that unpiping or that daylighting of streams could occur at subdivision stage. So I can't remember off the top of my head right now what that rule is, but that subdivision rule that captures that conversation around daylighting could occur at that stage. I think then the natural water bodies could be used for the land use element of that, so the setback from water bodies for earthworks and structures. So obviously wouldn't then apply to piped sections. So I think there could be the potential for those two, those two opportunities. And because there are, I think we have discussed this previously actually around at the hearings around when Carrington surveyed New Plymouth, he just surveyed a grid over the whole of New Plymouth. He didn't take into account any of the river valleys or the gullies that were across. So actually a really significant number of water bodies, and I can't put a figure on that, were in the New Plymouth urban area have been infilled and entirely deleted. But there are actually, on the proposed district plan, I just whilst Maria and Casey were speaking, I did have a quick look, and there's actually 2 significant water bodies in Waitara which are piped through the urban area, and they're actually not listed. They are listed as significant water bodies. So one is the Mangaiti. So Commissioner Dace, you might remember that from Plan Change 49. So that's actually identified as a significant water body, and it's piped right to the estuary where it enters into the Waitara River. So the piped area is actually identified as a significant water body, and also another one is the Tangaroa. So noting that the emissions from Manukurihi Pa Reserve Trust and also Manukurihi Hapu, that the Tangaroa hasn't been entirely mapped. So and from memory, the Section 42A, sorry, Ms Young's feedback to that was that the mapping of the Tangaroa follows Waitara Area A plan change, and I can't remember the plan change number off the top of my head. It may be number 17. But the Tangaroa actually flows to the Waitara River, so it's only mapped for a portion on the proposed district plan, but I appreciate it is listed in Schedule 9. Part of it is piped as well. And that's also referred to in my evidence, so that's a project that Manukurihi Hapu, Otarawa Hapu, Pukerangi Ora Hapu, Ngāti Rahiri Hapu, and Te Koteitanga o Te Atiawa are, in partnership with New Plymouth District Council, are looking to daylight lots of the Tangaroa as well, restore the Tangaroa. So there has been, over the past couple of days as well, there's been kōrero from Auntie Patsy, Anaru, Keith and Julie in particular, that there's an expectation that all water bodies in their rohe will benefit from the protection of the proposed district plan. There have been examples where applicants and innovative planning staff have, in my opinion, have resulted in good outcomes. I think the reality for us is that we can't always rely on that, so we do need to have good planning provisions which ensure that these behaviours are required at all times. And just to reiterate, as I said before, the optimal planning outcome, in my opinion, is that the rules apply to all water bodies, irrelevant of if they're urban or rural, significant, natural, or piped, depending on what the proposal is. So I think it's really, there has been some kōrero around the MPS freshwater management as well, and that the concept of te mana o te wai, so whether or not we're giving effect to it, or whether or not we're considering and recognising it. So I don't intend to expand on that too much, but just to I guess highlight that I haven't proposed any new provisions in terms of water bodies, new rules anyway. It's about that those existing provisions that have been provided or drafted are considered in light of that new framework, so the new MPS freshwater management. Now, there's just on a little bit of a tangent, so there's been a discussion around what the hurdles are to restoration potentially. So I think one of those hurdles is actually in the provision. So rural subdivision, for example, is an activity whereby, in my experience, the balance allotment, where it may have water bodies traversing that allotment, haven't really been considered in that in the assessment of the subdivision. So just making sure, and I haven't made any links to I just saw my notes in terms of the subdivision provisions. I guess that will be clear on Monday when we submit our next lot of evidence. That there needs to be clear provisions for that protection. And I'm highlighting that as a hurdle or as a barrier because that links back to the kōrero that Jamie and Te Poihi have given around all matters being connected. So Indigenous biodiversity as well can't be considered in isolation, in my opinion. And rural subdivision is the opportunity to provide for that restoration and that protection of water bodies at that time. So in relation to esplanade areas as well, so my understanding is that Schedule 9 has been used to identify all of those water bodies where esplanades would be required. And in my opinion, and which is articulated in my evidence, is that esplanades should be taken on all awa. I have recommended an avoidance policy and reflecting on Commissioner McMahon's discussion with Maria and Casey earlier, is that I probably haven't, I didn't look to all of the policies above and how the changes to the rules are recommended, and also to proposing a new policy wasn't reflected in the policies above. So I would be happy to also provide that in due course if I was required. But just to give a little bit of background, we work really closely with the Council's Open Space and Design team. They are the team that are responsible for the taking of esplanade areas, and in the background working particularly with Renee Davies, the lead, and in preparing a guidance document or where it is more appropriate to take esplanade and where it's not. And I appreciate that doesn't run, it's obvious, it will be a work in progress, and it's probably not something that will be ready in time for the proposed district plan. But just to let you know, that's what we are doing, so we are able to work closely to decide relatively quickly, yes, in esplanade it's appropriate if a width is this much, or it can be waived entirely in the event that there's another mechanism there. So perhaps the use of the Section 221 consent notice to protect any vegetation that's there, or that a planting strip is more appropriate in that instance. So we are having those discussions at the moment. Yes, so I just had a thought, and I didn't write it in my notes, but I have sent Julie a presentation reflecting on Commissioner McMahon's kōrero yesterday around affected party status. So I just wanted to highlight in particular some recent examples where we haven't been engaged or identified as affected parties, but also where because of the urban zoning, it hasn't triggered. The urban zoning hasn't triggered the earthworks or building setback rules. So I'll just quickly run through these. I actually, last night after we finished, just went for a little run. I think you could call it a walk. This is out in Bell Block, so I can provide the details of the subdivisions. I am mindful, and I did mention to Julie earlier that when I do go on site visits, I do let the applicant know that I'm taking them so that we have them on file at Te Kotaitanga. So if that's something that perhaps Commissioner Daish, instead of making these public, that they could just be for the panel's consideration. But anyway, these ones relating to 65 Connaught Road are actually taken from the Mangati walkway, so these ones could be made public if necessary. So the Mangati stream is a water body of importance to Puketapu Hapu. Traditionally, even in the present, have used it for its abundance and for mahinga kai. Maybe not so recently. The council had a sewage overflow, which ended up in court. But anyway, we can reflect on that later. So this is looking upstream. So on the left-hand side of the photo is the earthworks, and they are by far closer than 5 metres to the stream. So just trying to detail here that I know it really affects the prominence of the stream, and that natural character has been changed. And I can't remember what the landform was like prior to these works. So if anyone can provide any insight to that, I'd be grateful. But anyway, if you can move to the next one, thank you. So that's just looking downstream. So that's the Mangati on the starting from the bottom right-hand corner. Yep. Right, that's just on the Mangati walkway, looking back to the buildings that are on within the subdivision.
So this is around Bell Block, Sarah?
Yeah, so this is in the Bell Block industrial area.
So that's not the Mangaiti street. Is it the same
Yes.
waterway?
Yeah. Mangati, it's pronounced.
Mangati. That's the same one that flows to the Water River.
So that's the Mangaiti.
Okay, just want
Sorry.
to yeah.
So Mangati is Bell Block. So my understanding is that, so Manga is another word for stream.
Okay,
And
gotcha.
tea relates to the tikoka, so there was an abundance of tikoka
Okay.
along the Mangati. Or
So different stream, this is the mill.
different stream, Mangati, Mangaiti and Waitara, so this is the Mangati. So also the council have stormwater infrastructure in close proximity to the Mangati, which is closer to State Highway 3, which I may have a photo, I can't remember. Yeah. So just looking back to the subdivision as well. Yeah. Again. Good. So this one here, just looking back to that, so those of you on a smaller screen might be able to see it, but there's a retaining wall that's been constructed, and it was definitely within 5 metres of the Mangati there. There might be a closer up one, Julie. Oh yeah, there. So very close to the bank of the Mangati anyway. And just in the distance, you will be able to see it in the next photo as well, is that's actually the sewer line crossing the Mangati. Yeah, if you go to the next one. Oh yeah, just there. So that's the sewer line that's up above. It flows over top of the Mangati. And just to show there, the Mangati going into the two culverts over onto the downstream side of the road. So this is and to reflect on that one in Bell Block, so that's an industrial zoned property. So it wouldn't be subject to earthworks rules. I'm correct. It would be subject to only setback from buildings under the general industrial zone. So this property here is zoned residential under the operative district plan, and to be residential under the proposed as well. So in the far distance, you can see there is a landform, which if we go to the next slide. So that just on the left-hand side, there's a sort of runs on an angle. Yeah, next slide. So that angle there, so not to the top of the photo, but probably in the middle. So the applicant here was proposing to remove what is left essentially of the rest of that hill. They would have a direct view down into the Tihinui stream. Next one, please. So that's the area there. And if you could go to the next one, please. So that's the area just sort of in the middle of the photo, which was to be removed. And the next one. And so this is just from the opposite side of the river, and that area to be excavated. So under the proposed district plan, that wouldn't be, that wouldn't require resource consent. Yes, next one, please. So this one is a residentially zoned property in Bell Block as well, so it's within the Area Q development area. And so this area here is a gully. So on the proposed district plan, it's identified as it's actually identified as a tributary. And when I did visit the site so this is within Puketapu Hapuro here as well. When we did visit the site, that area was damp. I had gumboots on and I didn't attempt to walk through there. And go to the next one, please. So this is, I haven't put these in very good order, but this is a tributary of the Waitaha stream. So all of the streams in Bell Block and Puketapu Rohe, they actually run through the industrial area and then they run through the urban area. So this is a tributary of the Waitaha stream. Yeah, next. So this is on the right-hand side, so this is the gully. This is the gully that enters down into that tributary that I've also taken a photo of. So just where the tributary and the gully meet, that's been identified as a natural inland wetland. So the applicant was proposing earthworks. So in the previous photograph, they were proposing earthworks within 3 metres of the tributary. They were also proposing earthworks within 10 metres of the natural inland wetland. And so what they are proposing is that there will be a solid wall, that entire gully will be infilled. There'll be a solid wall at the 10 metres because the application would be, from memory, discretionary. What we highlighted through the process, so it would be discretionary under the National Environmental Standards for Fresh Water. What we then highlighted is actually that the tributary that they're proposing to infill would likely, and this was my own opinion, would likely stop any water entering into the natural inland wetland. So I think earthworks here are to about 5 metres in height. They vary, but up to about 5 metres in height. Yeah. So that was just looking back upstream along the tributary. I can also provide context to this as well. Or any supplementary information you require, Commissioner Dash. Yeah, it's just of the tributary as well. And sorry, that's obviously the same photo, looking back to the wetland and the inland tributary. Mm-hmm. That's looking down the, I did jump in the gully. So that's the gully looking back down towards the natural inland wetland. I think that was, or maybe for the maunga really. No, actually, if you could go back one photo. So this was just to show, so that is the sort of looking across the gully, so that gully will eventually be flat. Thank you. So this is just a photo of a water body in Inglewood, Kalitoa Street, which Anaru White mentioned yesterday as well. So here, the applicant has undertaken some earthworks to clear some of the soil from the awa. So that's looking downstream. Yeah. So that's another awa on the property. That's just looking back upstream, the works that have happened in close proximity. And looking downstream, so this is a wetland area that's been identified. Yeah. So just on that one, again to highlight, so that was one where the applicant was proposing to infill all of that to get a yield of about 30 allotments, I think. So we are continuing to work through the process with him, but again, this is one that wouldn't be subject to earthworks or building setback from those awa, from those wetlands.
I think the best way to deal with these is, we'll accept them as part of your evidence. This is prompts for us thinking about, you've provided examples. I don't think we need anything further. They do graphically describe the examples you've talked about in your evidence. So that would be fine to get through to us separately. Thank you.
Goodbye. I think that was all of the...
So we're ready for questions?
Yes, so anyway, kia ora. Ready for questions.
Okay.
Miss my hui, so all good.
Okay. Are you giving your apologies or?
Sure. Yeah, Sean's obviously cancelled it, so that's okay.
Okay. Thank you. Commissioner Coffin.
I missed you. I couldn't quite hear properly through the sound system when you explained your last name. And I was just wondering if you could say it again for me.
Mako whare mahihi. Mako whare mahihi.
Nice, that's cool.
So my great-grandfather just decided to drop the whare mahihi. His niwhai mako whare mahihi, and his father was te mako whare mahihi. So he just decided he didn't want the whare mahihi in the end.
No.
There's mako whare mahihi. Lovely.
Kia ora.
I just had a few questions for you in specific areas. The first one is in regards to mekotahi, an outstanding natural feature and landscape. And one of my questions, which you went some way to actually answering, it was just around the relationship or not between the outstanding natural features and landscapes, the sites and areas of significance to Māori and historic heritage, and in brackets archaeology, and I think you did well in describing, and what I heard was you say was site significance to Māori. It's important, but it's quite a narrow slice, and particularly spatially, and it doesn't consider the landscape level. And I just wondered if you had any further comments in that regard.
To reiterate, yes, that it is a site and area of significance to Māori, and that I probably didn't enhance that enough, but yes, definitely the land it provides for that landscape level consideration.
Thank you. And just in terms of, you said you agreed with Mr. Bain's assessment, and I was just wondering what your planning view is of what outstanding is. So just in terms, sorry, are you hearing things in the background?
No, I'm looking to the sky for inspiration.
Yeah, I suppose there's a bit of case law around about what's outstanding and what's, I won't say ordinary, but what's, the difference between what's being significant, then you're going up to those things that are outstanding, and that can be both at a district, regional, and national level. And it's things like being conspicuous, it's imminent, it's remarkable or iconic. It doesn't have to be all of those things. It can be any one of those things. And I just wondered if you had a particular view regards mekotahi and in the collection of those outstanding natural landscapes and features.
Yeah, well, in my opinion, that they have that. Ngā motu all together. I guess just taking inspiration from your words there, is that they are remarkable. It's that you can't find them, you can't find those motu anywhere else, particularly along our coastline like that. So the Ngāti Te Te Atiawa coastline.
Thank you. I'm just turning my mind to Te Mana Te Wai, and I think you helpfully said you hadn't recommended any particular provisions, but you thought that it should be on our minds at all times, and I thought that was really good guidance in terms of particularly those principles of Te Mana Te Wai and thinking about the hierarchy. They might not immediately be provisions in the plan, but the things that we're thinking about all the time. So I thought that was helpful. And I just wanted, for the purposes of this particular hearing, those additions and amendments that you've made at Appendix 1 of your evidence, that's been your recommendations in regards to giving effect to Te Mana Te Wai in this context at the present time?
Yes.
Is that the connection?
Yeah, in the present time, noting that obviously the plan is or how people perceive te taiao will change as well, and I think that's imminent in the direction that's coming out of the government.
I've got one last question for you, and perhaps I apologise if it's late in the afternoon for this one. I'm just thinking about, and this is something I'd asked Ms. Wakaida about, was the tension between some of the Part 2 matters. This is in regards to public access. And you've got Section 6C, the relationship of Māori and their culture and traditions with ancestral lands, water sites, wāhi tapu and other taonga. And I think we've been focusing in on sites, wāhi tapu and other taonga. But there's also Section 6D, where councils are, really need to, as a matter of national importance, provide for the maintenance and enhancement of public access to and along coastal marine areas, lakes, and we've been talking about rivers. So I just wondered whether you had a planning perspective in regards to resolving that tension.
Thinking about how to respond to that.
I know it's a 5:30. It isn't a 5:30 question.
I am happy to come back to you on that, but just one thing I'm thinking about is that we are just reflecting on what I said earlier, was that we are working with the council now on how to manage that, provide for that public access with the open space and design team.
I don't really want to put words in your mouth, but I was thinking, just today we've heard, a number of different approaches. One is at the site, responding to things that are happening on the site, and we had Mr. Manu, who explained about Hauhangapā, talking about signage, plantings and those types of things that can be done at site, and we've certainly through the submissions had recommendations in sort of small changes to policy and particularly focusing on the rules. But I was just wanted to get your sort of feel for where you thought the most effort, or what might be the most appropriate way of resolving those tension between two imperatives for the council in terms of its district plan.
Yeah, so I guess from in a regulatory sense, I think as well, I've had recommended a policy which restricted those. Yes, actually, right. on reflection, I had noted a change that needed to it. WB P9U, so avoid. It does say avoid public access to esplanade strips or reserves where there will be adverse effects on sites and areas of significance to Māori and water bodies. But I am thinking, I'm reflecting on the kōrero Māori I had earlier too, around, what is the intention of esplanade areas? Is it for access, or are they for other reasons, and where should they sit? So just reflecting on that policy as it's drafted, maybe it should just be avoid esplanade strips and or reserves. I guess that also probably doesn't answer your first question, but that's one approach to managing that approach with the council, in addition to the non-regulatory and working through that with identifying those areas which are appropriate for access, as a front footing that as well.
Okay. Thank you. Ms. Makowhare Mahihi. Just practicing there. Hey, thanks very much. It's late in the day, and I really appreciate, you've been through every day of the hearings, listening in, and you've presented this evidence. I know you're preparing other evidence for us in hearings, so fantastic job representing the iwi and your work bringing everyone together. Really appreciated. Thank you.
Kia ora.
Right, Commissioner Littlejohn.
Oh, kia ora, Sarah. I'm taking the easy route because I don't pronounce as well as my fellow commissioner. I hope you don't mind. Look, I enjoyed your evidence along with your colleagues, your cousins. They got me thinking in ways that I hadn't thought in a long time, which is fantastic. So I didn't have any specific questions, but one of the things you did say in passing, which I picked up on because it was probably a line of questioning I started with, was around the barriers to restoration of water bodies. And while you've been answering Commissioner Coffin's questions, I've been sort of doing a little bit of a digging because I hadn't really got my head around what happens on a rural subdivision if you have a water body. And it's probably something that sort of trespasses more into the subdivision chapter, but I just wanted to give you a heads up that it is something I am particularly interested in, given that the Waterbodies subdivision rule really doesn't do anything more than point a landowner that's subdividing to the subdivision standard 9, which is just around the Esplanade Reserve and Strip. So to that extent, you're right that on the face of the Waterbodies chapter, there's no real engine room there to require anything more proactive in terms of enhancing water bodies. But I did then trawl through subdivision rules, and I'm looking forward to Kotahitanga's evidence on this. Is I see that in all of the controlled activity subdivision rules, R4, R5, and even in R6, they're all controlled or restricted discretionary activities, but there are quite broad matters of discretion. And the discretion matters, which are matters you could impose conditions on, extend to the protection, maintenance or enhancement of natural features and landforms, historic heritage, water bodies, indigenous vegetation, sites of significance to tangata whenua, archaeological sites or identified features. So at least on the face of the provisions, there would seem to be a conditioning power available to the consent authority on all subdivision to actually, and even subdivision that doesn't trigger an Esplanade Reserve or Strip, to require some measures to be put in place to protect water bodies. And so I'm just interested in your thoughts on, other than setbacks for earthworks and buildings, what other measures do you think would have a tangible ongoing benefit for the protection and restoration of water bodies, assuming that they are to stay in private ownership and that no earthworks occurs next to them and no buildings are within a certain distance of them? What other sorts of things do you think could be included within conditions imposed upon a subdivision consent in that regard?
So specifically in relation to water bodies?
Yeah.
Well, in my experience to date and Marlene reflected on that yesterday as well, is the Taranaki Regional Council, they require dairy farms over a particular size to have riparian farm plans, riparian planting management plans, and so actually how we've been working is to date is we've actually been requiring where there is planting and fencing existing and proposed to be retained, maintained, enhanced, and protected in accordance with that farm plan. It's a it's been a real it has been a shift in the short time I've been with Te Koteitanga, I think, for a lot of, particularly for farmers, to then have so we've been requiring those by Section 221 consent notices.
Okay.
And where there haven't been plans, we've really pushed for farmers to have those, the applicants to have those planting and fencing to be undertaken as well. So although I reflect on that we as tangata whenua haven't been engaged by the Taranaki Regional Council in particular to inform that riparian planting management plan information. I think it's a good start until we can get the provisions in the plan, because at the moment, we're only relying on statutory acknowledgement essentially, which in my short experience at Te Koteitanga, it's not, and reflected on in my evidence, is something that we can't rely on that. We really do need those provisions in the plan for the protection and the restoration.
And I think you really need, to that extent, particularly if the activities are going to be controlled, you need a consent authority that understands what these sorts of matters mean, don't you?
Yes.
The example you gave, I think it was one of the last ones in your slides, of quite a dark coloured stream with no vegetation on the banks. Where was that picture of?
So that was in Inglewood. So that's an urban water body.
See, on the face of it, if that land was going in for subdivision under the new subdivision rules, as they currently are, then there would be there would be the power for the consent authority to actually impose as a condition of consent that from a certain distance that waterway be fenced and it have riparian planting put on it as a condition of the subdivision consent. On the face of this provision, do you think subdividers have sort of got their heads around that yet?
In my opinion, and I think I've mentioned this to in some of the other hearings as well, is that there's been a real shift in the development community. I think there's a spectrum. So there's some who were totally on board with it, and they already were. Those applicants were already that way inclined.
There's always stragglers with policy changes.
Yes, yeah. But also, some of the stragglers as well. So,
Okay.
I have great respect for the development community and the way that they have reacted to these changes that the iwi have. They feel that the iwi are imposing on them, but the reality is that what's good for Māori, in my opinion, I've said this before, is that it's good for everyone. So in particular, that Kelly Torwai Street example is that we have got to a point where they are going to protect the stream. Some of the stormwater infrastructure is going to be within the reserve that will be around the stream. They were originally proposing the stormwater infrastructure in the stream. So now they've finally brought it out, but that's because the National Environmental Standards for Fresh Water had other triggers. So I think we will eventually get to a really good outcome.
Well, I mean, I think that's really encouraging. When mana whenua can be seen as part of the solution and not part of the problem, it just makes the world a much better place, I find. And I think for land developers to knock first on your door and talk about their plans and how they're going to do things before they even go to the council would be a major milestone to achieve. And I think I'll be very interested to see what your evidence is going to be around these quite detailed subdivision rules, because they do provide an opportunity where people want to do things with their land beyond what they're already entitled to, where there can be some quid pro quo in a way. So yeah, I guess I'm really looking forward to the subdivision chapter, because it is an important one in terms of how you get measurable gains out of land change. So yeah, okay. Look, it's getting late. Thank you, Mr. Chair, and thank you, Sarah. That was very helpful, and I just want to echo the Chair's comments about how the efficiency and the coordination that you're bringing to bear on this case is much appreciated.
Thank you.
Thank you, David.
Yeah, thanks, Stephen. Thank you, Ms. Marco. I am going to keep this very brief. So I'm struggling. 3 questions, and they all relate to your Appendix 1. Okay, you've got that in front of you?
Yes, sorry, yes.
Okay. WBP9 new. It's a new policy avoiding public access to esplanade strips or reserves. Question there is, what objective would that policy affect?
Sorry, could you repeat that?
What objective would that new policy give effect to, in your opinion? What I'm trying to ascertain, Ms. Marco, is whether it's a policy sitting on its own or whether it's surrounded by a higher order objective that it's seeking to give effect.
Yes, sure. I'm just going to check the objective. So there is objective WB03, which talks about the adverse effects of activities on the values of water bodies are avoided, remedied or mitigated. And also WB04, the relationship of tangata whenua and their traditions, values and interests associated with water bodies are recognised and provided for. So also appreciate that doesn't, there's no reference there in particular to sites and areas of significance to Māori, but the tangata whenua strategic objective directions do make particular reference.
Yes, that was my next question, in fact. If there in fact was a similar policy objective in the SASM chapter giving effect to a similar objective, would you still see the need to refer to areas of significance to Maori in that new policy? Given that the objective and the policies relate primarily to water bodies and that there are other provisions relating to SASMs.
I think this is a kōrero that we did have. Oh, I'm sorry, I just remembered you. Were you on the Earthworks hearing chapter?
No, I wasn't.
So just to reflect on that, we did have a kōrero around the relationship between the Earthworks chapter and the sites and areas of significance to Māori chapter. So it was my opinion that the policy direction in the sites and areas of significance to Māori chapter did provide for the protection of those sites and areas of significance to Māori that aren't scheduled in the district plan, in the proposed district plan. So I think, yes, I agree with you that if you were in applying that provided.
Section 32 of efficiency perspective and avoiding duplication.
Yes, yeah. So provided that there is that implementation of the plan consistently, then I don't think that the WB04 objective would need to be amended to reflect sites and areas, that policy in particular, provided the plan user knew to go back to the sites and areas of significance to Māori chapter, and that there may be scheduled and unscheduled sites and areas.
Understood. Thank you for that answer. Second question relates to the blue strikeout of both the notified term of significant and the 42A proposed term of scheduled, and then the reliance on natural water body as the operative term. Have I got that right? That's what you're asking for?
Yes, but just further to the verbal summary that I've given, and reflecting on Maria's kōrero during her presentation, is that for land use, I would consider natural water body appropriate for so WB, R1, R2, R3, and R4, but for subdivision.
R5 and R6, yes.
Yes, R5 and R6 to amend that natural water body to just water body.
Just so I've got the clear, water body is the term that you'd like to prevail in relation to land use rules. But for subdivision rules, you'd amend it to water body, is that correct?
Yes, correct. And that more aligns with the definition of significant water body, the current definition of significant water body in the plan.
So that implies access to water bodies, regardless of whether they're natural or not, is the goal, whereas the term natural water body is about preventing adverse effects from land uses, appointing the water body. Is it as simple as that?
Yes, but I think water body includes a natural water body, with the definition of natural water body, so that those effects would also have to be considered at subdivision stage as well.
Right, okay. Okay, and my final question is just a general comment. I'm sure the chair will pick up on this, but and you in fact made a comment earlier this morning, I think, about it might be nice to have a consolidated version of tangata whenua proposed changes, if that was possible. And if that was possible, I guess you've used blue text, which I think has been the realm of the officers up until now, and your colleagues have used red text for changes. Now, that's a very pedantic point, but when it comes to deliberations, we just want to make it as easy as possible to stand the respective positions of different participants.
Yes, thank you. Good point. And also on the consolidated version, I guess we also had a kōrero about that during our debrief last night. So around the preparing a consolidated version, and noting that that between the three of us, we all have these small variations. So we'd be happy to consider potentially consolidating those, but also potentially providing the differences as well, which in most instances are very minor.
Look, I think that would still be useful. Okay. That's all for me. Thank you for what's a very long day.
Cool, thank you.
Thank you, Sarah. Just following on from that suggestion, I'm quite aware that yours and Ms. Bellaby's evidence is focused around the Te Atiawa submissions, and Maria's focused around the Taranaki iwi, the Te Kahui mission. So there are differences, and I'm not sure in my own mind whether it's appropriate to consolidate. Perhaps a marked up red, red-blue markup in terms of yours and Casey's would be helpful. And we already have Maria's markup in front of us. So just thinking on reflection, that there isn't, in terms of the final provisions and outcomes and where the derivation of scope comes from, there are differences. So requesting sort of an overall iwi group might not be possible or easy. So is that your preference?
So we did have that kōrero as well, noting that we are working for different organisations.
Yes. So I think while there's a lot of consistencies, I think the proper due process would be for Te Atiawa, you and Casey to prepare a markup in the form that we've seen before. I've also noted that you have just made a couple of changes to some of those, that one we just discussed with David. Mm-hmm. So where you have thought further, it would be acceptable to receive that on the basis that it's clearly titled post the hearing discussion and highlighting matters that you've perhaps reflected on. Mm-hmm. And that will advance things. And I think just as long as there's a date and we can differentiate it.
Yep, sure.
That would be great. I did have just one question on your, I shouldn't apologise because this is important. On your Schedule 1, your Appendix 1, I'm going to find it because it's Casey's. This is yours here. Just so I understood the strikeout of WBR 6. Mm-hmm. What's the effect of that? You've probably outlined that in your evidence. So it's a restricted discretionary rule. You're seeking it be deleted. What's the effect of deleting it?
Because there were two rules in relation to waterbodies. Mm. So one was subdivision of land containing or adjoining a natural waterbody, which is WBR5, and WBR6 was subdivision of land containing or adjoining a scheduled waterbody.
Okay, so it's just that. Yes. Okay.
And in terms of the activity statuses.
Yes.
I think when I was preparing this, it was. I didn't give that consideration around the activity statuses.
So does it? If it's not there, is there some sort of cascade through to non-compliant? I'm not. I just had to. Yeah.
Just means that all subdivision containing or adjoining a water body would be controlled or restricted discretionary, but the WBR6, if it were retained, it would be restricted discretionary or discretionary. And also, just referring back to my presentation as well, is that in the matters over which discretion is restricted, for WBR5 is that the policies are referred to in there as matters to consider, and given that the changes I've made to the rules, I think I would need to go back and look at those policies as well.
Okay, I think that just highlights for us looking at these policies in these changes in the context of the whole set of provisions where certainly where Ra and Denise have got to in the section 42 and then building on that provides a roadmap and how they relate to each other. So that's why I think just for the future, and you'll give us this update anyway, that does help us a lot. Yes. All right, that was the only question I had, and I thank all three of you. I think you referred to yourselves as planning angels. Commissioner Coffin referred to you as something else, which fuzzy something, but do really appreciate, and the way you've worked together and obviously supported each other's just fantastic. There are some procedural matters to deal with. I'm looking at the clock, and I don't want to. There's quite a few things to cover. I don't really want to delay us, so I'm thinking that I'll just signal what they are, and we can pick those up first thing in the morning when we're all fresh. The first thing is just the arrangements around our directed joint witness statement or planning conferencing for your chapter, Ms. Macbeth. We just need to talk about scope, timeframes, who's involved.
Yes, I have some questions about that.
Yes.
Some clarity would be good.
Yes. So do you want to just perhaps give us your questions now? And
Is that okay? That would be...
well, I think because we're because we're separate, as a panel separated, it's quite difficult for us to confer as we normally would. So if you could put your questions on the table now, and then we can all ponder those overnight and think about them in the morning.
Thank you. So I've been in contact with the planning experts that have appeared at the hearing with planning evidence on the eco chapter, and we've scheduled conferencing to take place on Friday at 1 p.m. Just a question around, so Ms. Walker didn't, she stated that her evidence was not in the capacity of a planning expert, so I have not invited her at this stage, but I was wondering whether to extend that invitation.
Is Ms. Walker a qualified planner?
Her position is policy analyst, I believe.
So Federated Farmers haven't led expert
No.
planning evidence, so I think they're in the same boat as Forest and Bird. So we will think about that by initial. I know, Ms. Walker, you're listening in. My initial view is that probably would provide a problem for expert conferencing.
That she hasn't submitted expert evidence, so we wouldn't.
Yes, I suppose the expert conferencing relates to a profession, area of expertise where people have taken the code of conduct and are giving us expert evidence in that capacity.
Yeah.
So that's my initial view. I'll confer with the panel overnight, and we'll come back to you on that point.
Okay. A question was raised on that same matter about the appropriateness of Mr. Kiss attending. So he has been invited and wishes to attend, but then this was questioned about him being a planning expert as a surveyor, experienced in land development. And in his evidence, he stated he considers that he is an expert, and he's included the statement about the code of conduct.
He sees it as an expert in the subject matter.
Yes.
Of SNAs and
the local planning development.
Look, again, we'll ponder that and come back to you on that in the morning.
Okay, and there's...
So who was raising the concern there? Was there one of the parties not?
Mrs. Hokapora.
Okay. Yes, sure. Okay.
And then Ms. Johnson and Ms. Carville have replied that they don't think they need to attend. Ms. Carville, if you recall, her concerns on the eco chapter were she agreed with the So, and Ms Johnson, most of her concerns are around subdivision.
Yes.
And I've indicated, because I indicated in that email to people that I thought we would be focusing on the land use. We wouldn't be focusing on subdivision.
Yes.
Yeah. So, just to check with you that
Yes,
those two wouldn't be
that-
expected to attend.
That seems appropriate.
Thank you.
Yes.
So, well, we could just, are we going to discuss it tomorrow as
We'll
well?
discuss timing around reporting back and things as well. So,
Yeah.
yes.
So I guess just one more comment. Ms Ratt just noted that, you know, we'd probably get better outcomes if we have focused particular questions. And I thought an approach would be to step through the provisions for a start and just to lay out to you who wants what.
Yes.
In a table kind of form, or, you know, present it in a way like that. But if there
Definitely.
were any other key questions that you would like a statement on, then
No, we have one of these WeChat sort of things we do as a panel. And we've been relying on that. But in terms of scope, I do think it's the provisions.
yeah.
And the reasons where there's agreement of everyone, that will be clear on the face of the provisions. Where there's differences, that's when we're quite keen to understand and the reasons for that. Yes, so there's no, apart from that, and I think those reasons will tease out the issues. You know, we certainly have the evidence, but bringing those issues and reasons to the fore in a single statement will be quite helpful for us.
Yep.
Yeah.
You okay then? Thank you.
One thought that does bring to mind is that from the three planners here, 32 AA's quite important. So I do think you need to deliver that. We've asked Ms Yosen to do that, and I think I haven't seen it yet, but that's come through from Ms Yosen, the 32 AA analysis from DOC. And if you're planning on Friday, that's not a lot of time, but I think some thoughts, particularly given Commissioner McMahon's questions about risks and of acting and not acting, so I do think that should be prepared and on the table for the planners, and it will be an enabling wire for your process as well when you're thinking about reasons, and be quite important. So if the reasons can capture some of those 32 AA type rationales from a planning point of view, that would be super good.
Okay, one more question, sorry.
Yes.
To extend the invite to Ms Mako, because she hasn't presented expert evidence on this chapter, but I would be more than comfortable for her to attend.
As a planner working for Te Atiawa, we'd better have a chat about that as well.
Thank you.
I just don't want us to get a problem with any procedural criticisms. So it's Mr. Kiss, sorry. Ms Marco
And Ms Walker.
and Ms Walker.
Mr. Chair,
Yes.
if I was in the room, I'd be pulling your coattail, but I'm not. So I'm making a noise in front of the whole room instead. I'm wondering whether I mean, I understood we've now got through all of the evidence, and that tomorrow is to hear from staff. Is that right?
That's right.
I'm wondering whether we might conference prior to the hearing tomorrow to discuss some of these issues and where things are going to go, and give the staff maybe another half an hour or an hour to prepare themselves before a verbal response to what we've heard, just so that we can give some clear guidance on what we're looking for.
In terms of the right reply matters.
Yeah, and the conferencing, which is to some extent sort of less joint witness statement in my mind, and more just consolidated provisions that we can see the differences between the parties and be able to assess the relative merits of them. So, but look, I think that's something I'd like to have a conference with you and the other commissioners with in the morning before we launch into telling everyone to do a whole lot more work for us.
Sure. So you'd agree that the 32 AA provisions from the iwi planners are important.
Well, 32AA is important for any person who is commending changes to a notified document, as I see it. So it's a key part of the evidence giving in that sense, just as it's a key part for us ultimately to run that ruler over anything we do.
All right, so let's, I'm thinking about timing for tomorrow. If we were to have a conference as a panel, I don't want to do it too early. We're sitting late and starting early as it is. If we did that at 8:30 and then perhaps report back after that at 9 o'clock when all of the other parties are here.
Yeah, over to you, Mr. Chair. I mean, I'd be happy if we started at 9. I mean, no one is expecting to be giving evidence at the dot of 9. But of course, that's over to Julie to see what she sort of thinks that will do to the whole program. I don't want to run foul of the hearings administrator. That's worse than anything.
So we're back at the council tomorrow, as I understand it, Julie. And we do, as a panel, we do need a conference separately. So we can do that over a separate Teams session I can set up. If we want to talk as a panel together before we come back and talk to the hearing. That's so in terms of timing, if we did that say at 9 o'clock, and we'll start the formal hearing at 9:30, and if there's any time required to ponder and come back to us, we can deal with it then. Okay, so is that clear enough? We'll start tomorrow at 9:30. In the meantime, we'll have a chance to conference as a panel, because there are a range of other issues I'd like to have a talk to the panel about as well. So that would kill two birds with one stone. All right, so that's one issue. There is the issue that we have signalled, or Commissioner Littlejohn's signalled about this whole subdivision matter and relationship through the plan. So are you prepared to discuss that with us tomorrow?
Yes, I mean, I could do it now, but I'm
but that
happy to do that tomorrow.
That can happen tomorrow. And also, I think there's this general issue that Commissioner McMahon's raised about the Section 95 processes, how that relates to what might be in scope or not.
We do have a comment on that,
yes,
which we can provide tomorrow.
You can provide that tomorrow?
Depends how far you want to.
No, that's what I'm just sort of noting within the matters that we're expecting perhaps some feedback on, so you're on to that one. The other matter we have is Ms. Wakaira, you are preparing some further supplementary submissions on a number of matters, and we'd ask for those to be delivered by the end of tomorrow. Is that still on track?
By the end of tomorrow, sir.
Was that what we talked about, or was it?
I was labouring under the misunderstanding that when we were talking, you were talking about next Wednesday. I can provide them by the end of tomorrow. I did think that the time frame was a bit long when we discussed yesterday, but I've clearly misunderstood. Okay. So I can provide the matters by the end of tomorrow.
And we did say that we thought once we had that in hand, we could get Ms. Wallace to provide us some advice as well based on the matters that you're raising. So I think that's the process we'll follow. And
actually, sir, I should just note that perhaps you had originally said Wednesday, Thursday, and I'm conscious that while I might complete the matters by Wednesday afternoon, I'll just need to take instruction on my supplementary. So would Thursday morning be?
Yeah, well, look, by the end of Thursday will be fine.
Oh, certainly, sir.
Because I think what things in my mind is that we need that at hand before the officers do the written right of reply, and with the insertion of a conference or whatever we decide to call it, we will need to look at the timing after that to provide enough time for the officers to come back to us. So I think by this Thursday, end of Thursday will be fine. And then
I'm glad we clarified that, sir, in terms of the timing.
Yes. All right. Thank you. So that's another matter. And look, the last matter I have is I have received a letter from PKW, which I think has been signalled. We haven't had a chance to talk about that today, and I thought that that is a procedural matter, and if we could deal with that in the morning, because I do think we'll need some further explanation of the letter, and just to see whether you're going to be, that's going to be part of your further legal submissions covering that, Ms. Wakara. So that's the last matter I had on my list. That letter, I think, has been circulated to the other commissioners, and that's one of the matters I wanted to talk about in the morning. So with that, finally we can wrap up the day, I think. Are there any other questions? No, thank you. So we'll adjourn until 9:30 tomorrow morning in the council chambers. Oh, the chambers in the room. It is a council chamber. Okay.
Kia ora, Chair.
Kia ora, Kia.
E ko motu tā mātou mahi mo tēnei wā. E kite ana au ki Te Pōhihi. He's on, Te Pōhihi's online. I'm not sure if he's listening. Kei a koe taranga tere, whakakapia tātou hui?
Ai, ka te tino wakarongo mai rā ki ngā kōrero I puta mai I tēnei o ngā paipai.
Kia ora e hoa.
Wi o no mihi ka wake raki koutou, te paipai, wakatau kaupapa, McMahon, Little John, Commissioner Coffin, Dace, I can keep ka kiti o ingoa, mihi ka wake raki koutou, mai anō hoki, me o tata nei iwi no tō tata nei maunga, taranaki tui te ao tui te pō. Mihi ka wake raki o koutou kaha maia, e te wakatako tō kaupapa I tēnei wātone. Nōri rā mihi ka wake rā ki tātou. Manawa tēina, manawa toka, manawa tēina, tēnei hoki tō manawa tēina, ka pauta ki tēnā noha te manawa ora. Ora ki te bōra ki tāwhi tō e rongo he wakatia ki runga pūturu wakamāua kia tēnā. Tēnā. Hui e. Tēnā koutou.
Tēnā koe.
Tēnā koe te pui.
Homare.
Okay.